Welcome to Balance of Forces, an independent platform that provides current affairs and business analysis. In this episode, we discuss a very important topic around mandatory vaccination and its relationship with the Constitution and human rights. My name is Badaung Khozokwan, and I'm joined by Jamie Mighty, Senior Analyst. Jamie, before we get into the meat of this topic, I'd like to understand your opening remarks and comments around this very important discussion.
So this is indeed a very important discussion, and it's one obviously that is occupying the nation's imagination. And I've got two things I want to say as opening remarks. Number one, this is a limitation discussion. And when you are looking at a limitation discussion, talking about the limitation of rights, you must immediately familiarize yourself with Section 36 of the Constitution, which says the following: the rights in the Bill of Rights may be limited only by a law of general application to the extent that that application is reasonable and justifiable in an open and democratic society based on dignity, equality, and freedom, taking into account the relevant factors, which include: number one, the nature of the right. Number two, the purpose and importance of the limitation. Number three, the nature and extent of the limitation. Number four, the relationship between the purpose and the limitation. And number five, whether there are less restrictive means in achieving that particular limitation. I say all of this to contextualize that there must be a way up. And unfortunately, and this is my second point by way of introduction, I am disappointed by the quality of analysis that is coming out of some of the media publications that are really trying to grapple with this topic, because it has been superficial, it has been very shallow. I haven't seen, for instance, in many of the publications, a discussion of the Prince case, a discussion of the Pillay case, a discussion of a Christian education case, a discussion of S versus Kaba and S versus Kaba, which are important cases which inform how we must think about limitations and the balance that needs to happen when you are limiting rights. So those are my opening comments, and I think this particular episode is going to be so important in laying the groundwork for many people to help themselves think about this question and where they stand on the issue.
Okay, Jamie, let's get into it. Our time is running. What are the social developments around vaccination mandates?
That's a great question. So what we know for now is that some companies have already mandated vaccines. And it started with Discovery, and then it accelerated. And in fact, Discovery probably gave some other companies the confidence to do this. So far, these are the companies that have made vaccines mandatory. Anglo American, with effect from 2022. The MTN Group, Standard Bank Group, Sanlam, Discovery, of course, Old Mutual, Mediclinic, Life Healthcare, and Curo Holdings. In addition, several universities have indicated that they are also going to mandate vaccines for access onto campus. Which universities? The University of Cape Town, the University of the Witwatersrand, UWC, and UFS, the University of the Free State. So UWC is the University of the Western Cape. So that is where we are in terms of how are corporates and how are institutions of higher learning responding or addressing the issue of vaccines.
Now, you mentioned earlier around the media and social commentary around the vaccine mandate and sort of narrative.
Yeah.
What has been the narrative, media and just commentary?
Yeah, so I'll point out to prominent social, let's say radio commentators, public intellectuals, as well as what the mainstream media has been saying. So let's start with Bongani Bingwa, who is the host of the morning show on 702, which is a prominent talk radio station, in fact, the largest talk radio station in South Africa. 3 tweets will typify what is happening out of the content chamber that is 702. He says in one of his tweets, which was on the 29th of November, "We are staying on level 1 for now, but be warned, vaccine mandates are coming. If you keep refusing to take the jab for no valid reason, you are the one to be inconvenienced. You stay at home or you pay the price of regular testing. Finish and clap." That's 29 November. Then he says on the 1st of December, "Vaccination mandates work, From a fifth of workers previously jabbed, Discovery now reports 94% inoculated. Why? Because they stopped giving employees a choice. The tide is turning. Then on the 6th of December, he says, anything less than a vaccine mandate will be a dereliction of duty. We can't dither anymore. It is a question of leadership, and it's an urgent one. The longer this decision is delayed, the more citizens will be inclined to resist tougher restrictions. That's what he says on December the 6th. So that's the content coming out of 702. Then Pierre DeVos, a constitutional lawyer and somebody who is given a lot of access to speak about constitutional issues. He's a professor, obviously, at the University of Cape Town who deals with constitutional law. He has shared articles on his Twitter account, one from News 24, which says, science is on the vaccine mandate site, and another on News 24, which says, does the Constitution allow compulsory vaccination? Yes, it commands it. And then there's another thinker on Twitter who actually called for a vaccine mandate in that SASSA recipients must show proof of vaccination in order to access their welfare grants. And this is Louis Van Rijn. Louis Van Rijn said that. Now, when you look at the media articles, what you'll see is the following. Ben Winks writes in News 24, does the Constitution allow for mandatory vaccination? Yes, it commands it. Then you go again to Business Day, which offers an editorial opinion. Ramaphosa's instinct in the vaccine mandate is correct, so drop the task teams and act. That's the editorial opinion from Business Day. So they support a vaccine mandate. Martin Kingston, he writes in Business Day, mandatory vaccination, it's not about coercion, it's about responsibility. So that's a pro-mandate article. Then you have Fin24, which is within the News 24 network, which says, mandatory vaccination policy leads to 94% of Discovery staff getting jabs, which is also in support. And then you have another article in support of the vaccine, written by an anonymous entity, something that I have a problem with, but it's a story for another day. Sergeant at the bar, and I suspect that it's a constitutional professor. I'm not sure which one, but it's any of those that come to your imagination. The constitutional professor writes, or the sergeant at the bar, or maybe Umakeza, you never know, writes, science is on the vaccine mandates side. So that is what the sergeant at the bar, quote unquote, writes. So you can see that there is opinion that has been formed. And NEDLEC has taken a position saying that they also recommend to the government that vaccine mandate should be implemented at workplaces and that some venues should only be accessed by vaccinated persons. And this was confirmed by the Labour and Employment Minister, Thulas Nxesi, as well as the NEDLEC Executive Director, Lisa Seftel, right? So this is the position from the commentariat. Even Eusebius Makeza has shared some of the articles that Professor Pierre DeVos has shared, and he's another well-recognized public intellectual. So basically that is the position of business media, as well as News 24, and also you inevitably Daily Maverick. So you can see that there is a consensus forming in one section of society that says you need to accept these vaccine mandates and they are justifiable. But that's not the analysis, and that analysis has not been done.
For the benefit of our viewers, what is the nature of a vaccine mandate?
So a vaccine mandate, if it's coming from a company, if it's coming from an institution, such as an institution of higher learning, it's a policy that applies to all of the people who are within that institution. The university would be students and staff of the university. A company would be employees of that particular company. So in that instance, it's a policy. At a national level, a mandate is a law. It is a law that compels people to comply with it or face the consequences of non-compliance. So that's what a mandate is. Now, mandates can vary depending on the content of the law. As you can see, there is a suggestion that it be around limiting access to particular places, limiting access to particular resources could be another one. So that's one of the options. In other countries, they have done lockdowns for the unvaccinated. That's something that was done in Austria, for example. In other countries, they've done mandates differently. So the detail of a mandate is not universal. It's determined by the policymakers of that particular territory.
Jamie, let's understand this. What is the nature of COVID-19 vaccines in general, and with specific respect to efficacy in controlling spread, mutation, and mortality?
From what we've been hearing from the scientific community, we know for certain that vaccines do work. It's not the position of, our show that vaccines don't work.
It's a science.
We understand that and we accept. And in fact, let's not even make it like it's our position. This is the nature according to the scientific data that has been peer reviewed and is verifiable by anyone. Vaccines work, right? When it comes to efficiency of the vaccines, they are very efficient in preventing death and extreme cases of COVID-19, which obviously lead to hospitalization. They are about 50% efficient in reducing the contraction of COVID-19, right? So we've dealt with the issue of what do they do for you, but they help protect you from contracting COVID-19. But the protection from contraction is not 100%. When it comes to mutation, we know that mutation happens within a carrier, and it is a spontaneous thing. So both the vaccinated and the unvaccinated can contract COVID-19. Of course, the vaccinated contracted at a lower rate. But within those who have contracted it, mutation is spontaneous. And some mutation then leads to these variants that we have seen. So even in a vaccinated country, you can still have mutation. So on the hierarchy, the COVID-19 vaccine is great for preventing mortality, for preventing extreme cases of COVID-19. It is not 100% efficient in preventing spread, although it does help prevent spread in that those who are vaccinated have a lower chance of contracting COVID. And then when it comes to the question of mutation, mutation happens spontaneously within a carrier, and a carrier can be vaccinated and unvaccinated. So that's what the scientific consensus is at the present moment.
Okay, let's get into the issue at hand. What are the key constitutional principles to bear in mind when looking at this question of mandatory vaccination?
So I think let's start with addressing the issue of dignity. And the issue of dignity is important to understand because dignity is linked with freedom, and dignity must be considered in a limitation analysis. And in fact, the Constitutional Court has said as much. In the case of Dawood and another versus the Minister of Home Affairs and others, this is what the Constitutional Court said about the value of dignity. The value of dignity in our constitutional framework can therefore not be doubted. The Constitution asserts dignity to contradict our past, which human dignity for Black South Africans was routinely and cruelly denied. It asserts it too to inform the future, to invest in our democracy and respect for the intrinsic worth of all human beings. Human dignity therefore informs constitutional adjudication and interpretation at a range of levels. It is a value that informs the interpretation of many and possibly all other rights. Then the court goes on to say, human dignity is also a constitutional value that is of central significance in the limitation analysis. It goes further to say, human dignity is a justiciable and enforceable right that must be respected and protected. Right? So that's what the court says about dignity. Remember, I say that dignity must be considered in a limitation analysis. But also, dignity is linked. It's intricately linked to freedom. In the case of Ferreira versus Levin and others, Ackerman J. wrote the following: human dignity has little value without freedom. For without freedom, personal development and fulfillment are not possible. Without freedom, human dignity is little more than an abstraction. Freedom and dignity are inseparably linked. To deny people their freedom is to deny them their dignity. Why am I bringing this up? I'm bringing this up because there are questions that must be considered around freedom, around dignity, and around the rights that are being limited when you impose a mandate. And it's important to underscore that when you are talking about limitation of rights, it's important to think about these things. And the Constitutional Court held in Minister of Home Affairs and another versus Fori, as well as in Lesbian and Gay Equality Project and others versus Minister of Home Affairs, the following: the development of an active rather than a purely formal sense of enjoying a common citizenship depends on recognizing and accepting people with all of their differences as they are. So this is about accepting that people are different, people exercise their freedoms differently, and we have to respect their dignity, right? So now, when you ask me the question, what are the issues at stake in this particular consideration? Here's what we need to consider. We need to consider the public interest, and we need to consider the rights which that public interest is competing with, and whether or not it meets the constitutional standard of Section 36 of the Constitution. There are two tests there, right? Actually, yeah, three tests. Number one, is a limitation of the right reasonable? Then, if you can prove that it's reasonable, is it justifiable? Then if you can prove that it's reasonable and justifiable, you still need to show that it achieves the purpose and also that they are not less restrictive means to achieve that same purpose. Right? If you can't meet any of those tests, then you are in trouble at the Constitutional Court, right? So what rights are at stake here? What rights are impugned? Let's start with Section 12 of the Constitution, which deals with freedom and security of the person. Specifically, 12.2 states the following: everyone has the right to bodily and psychological integrity, which includes the right to A, make decisions concerning reproduction, B, to security in and control over their body, and C, not to be subjected to medical or scientific experiments without their informed consent. Then you go to Section 15, which deals with freedom of religion and opinion. And it specifically says that everyone has the right to freedom of conscience, religion, thought, belief, and opinion. And it's key to mention this because there are some people who believe that this specific vaccine has spiritual and religious implications, right? And it's not for us to critique their beliefs. It's for us to understand that they may hold those beliefs sincerely and genuinely and hold them as central to their faith. Section 29 of the Constitution states that everyone has the right to a basic education, right, including adult basic education, and B, to further education, right? So that's Section 29(1). So those are the constitutional rights which are, and also there is the right to occupation. So there are potentially four rights that a mandate actually could violate or limit. In addition to that, it's important to highlight what the National Health Act 61 of 2003 says. In Section 6 to 8, it discusses how consent must be established. Consent must be informed for medical treatment. It must be specific. And critically, it must be freely and voluntarily given. So when you go to Section 6 of the National Health Act, it says that a user is meant to have full information around the treatment that they are going to receive. And it even goes on to say that that information must be even in a language that the user understands, right? From the healthcare provider. Then it deals with, in Section 7, consent of the user. It says, subject to Section 8, 8, a health service may not be provided to the user without the user's informed consent. Right? Then in section 8, it also says that the user must participate in decisions. A user has the right to participate in any decision affecting his or her personal health and treatment. Do you understand? Do you understand what the National Health Act is saying here? It's saying that in order to get consent, and for that consent to be meaningful, it must be informed consent, must be specific, and it must be freely given, voluntarily given. It cannot be given under duress. It cannot be given because someone is being incentivized. It must be given freely. Consent that is given under duress, under threat, or under any conditions which constitute coercion is not necessarily free and meaningful consent.
Okay, Jamie. You've made us understood the constitutional principles. You've made us understood the possible clashes with implementation of the vaccine mandate. Now, I need to understand this. Section 36, limitation. What is the test and what are the key factors to consider?
The relevant cases to consider when trying to understand how does the Constitutional Court approach the question of limitation of rights, specifically with reference to Section 36, is MEC for Education, KwaZulu-Natal versus Pillay. In addition to that, you can also look at Prince 2, which is the case which is formally referred to as Prince versus the President of the Law Society of the Cape of Good Hope. This is a 2002 case. And Prince deals with this idea of less restrictive means. Because remember, you have to show that it is reasonable, you have to show that it's justifiable, and also that they are not less restrictive means of achieving the same purpose. So these are the cases. But just to give people an understanding of the fact of the case, what happened in Pillay is that a young lady was attending a Durban high school, and she was of Hindu religion and tradition. She wanted to put a nose stud in her nose, and the school said that was not going to be allowed, and they took her through a disciplinary process. And the mom said this is a critical part of her religion and her tradition, and then took the case to the Equality Court. They lost in the Equality Court, but they subsequently won in the courts that they went to after that, right? Including the Constitutional Court. And this issue was traversed robustly in those particular cases. In the case of Prince is a practicing Rastafarian up to this day. And at the time where he took this particular case to the courts, he wanted to register his contract of community service with the Law Society, which is required by the Attorneys Act. Now, the Law Society refused to register his contract because Prince had already gotten 2 convictions for the possession of cannabis, and he expressed his intention. He was quite a radical guy.
He was a Rasta man.
He said, I'm going to continue using what the court even referred to as holy herb, and said that, his practice as a Rastafarian required him to. Now, the Law Society took the view that a person who expresses his intention to continue to break the law is not a fit and proper person to be admitted as an attorney. To be admitted as an attorney, you do have to be fit and proper. It's part of the standard. Now, let's look at what was then brought up in the case of MEC for Education, KwaZulu-Natal versus Pillay, the Pillay case, right? Where the reasonable accommodation question was explored. In the first instance, the definition was provided of what is a reasonable accommodation. A reasonable accommodation, and the court here relied on the Employment Equity Act, which is any modification or an adjustment to a job or to the working environment that will enable a person from a designated group to have access to or to participate or advance in employment. And then the court went on to discuss the core principle. At its core is the notion that sometimes the community, whether it is the state, an employer, or a school, must take positive measures and possibly incur additional hardship or expense in order to allow all people to participate and enjoy all of their rights equally. Right? That's what the court was saying. And then they went on to say, the principle of reasonable accommodation, it ensures that we do not relegate people to the margins of society because they do not or cannot conform to certain norms. And further, there was reference to the case of Christian education, South Africa versus Minister of Education, wherein it was pointed out that the state should, wherever reasonably possible, seek to avoid putting in this, because Christian education was dealing with church issues, so it was a religion case, and it said the state should, wherever reasonably possible, seek to avoid putting believers into an extremely painful and intensely burdensome choice of either being true to their faith or respectful to the law. Right? But then the court goes on to say that the test is not just limited to reasonable accommodation. So it's not just reasonable accommodation that you may look at. And they stress in paragraph 78 that there may be circumstances where fairness requires a reasonable accommodation, while in other circumstances it may require more or less something completely different. But they give the criteria for when reasonable accommodation must be looked at. Reasonable accommodation, number one, is most appropriate, whereas in the case of Pillay, discrimination arises from a rule or practice that is neutral on its face, but is designed to serve a valuable purpose, but which nevertheless has a marginalizing effect on certain portions of society. Number two, the principle is particularly appropriate in specific localized contexts, such as an individual workplace or school, where a reasonable balance between conflicting interests may more easily be struck. So that's what the court said about the reasonable accommodation. It's important to think about reasonable accommodation because when thinking about the vaccine mandate, you need to think about the context wherein people have been working. In the global corporate atmosphere or world, people have been working from home. They've been meeting online. They've been also, getting into public workspaces, being required to double mask, being required to sanitize, to social distance, etc., etc. So there is an argument that can be made, and I anticipate will be made, that work can continue without a mandate being mandated by companies and a state, because reasonable accommodations have already been made for people who are unvaccinated to participate in the workplace and in society. And we must point out that a person who is unvaccinated poses a risk, but there is not necessarily a guarantee that they will give you COVID-19 because they may not have it, and also they may take all of the necessary precautions. Social distancing, double masking, sanitizing.
So those precautions, is that the less restrictive means?
Those could be the less restrictive means. But what I'm specifically talking about now is that there is potentially an argument that reasonable accommodations can be made. Now, when it comes to the less restrictive means, this is where Prince was a critical case, because in Prince argues in the case that his rights were infringed, specifically his right to freedom of religion, to dignity, to pursue the profession of his choice, and not to be subjected to unfair discrimination. And he was obviously proscribed from consuming cannabis by Schedule 2 of the Drugs Act, which listed cannabis as a undesirable drug-producing substance, and by Section 22A10 of the Medicines Act, read with Schedule 8 of the Medicines Act, which prohibited the use of or possession of cannabis except for research or analytical purposes. So the Constitutional Court, in its examination, in the core examination of the Prince case, Prince 2, was whether or not that prohibition went too far, whether it was overbroad, right? And what they then said, what the court said, is that indeed it was overbroad. They found that it was overbroad and that there were other ways, right, to actually protect and achieve the public policy concern without necessarily limiting all use of marijuana for religious reasons. And in fact, at para 81, what happened there in the judgment which was penned by Ngobo J, he says the following: I accept that the goal of the impugned provisions is to prevent the abuse of dependent producing drugs and trafficking in those drugs. I also accept that it's a legitimate goal. The question is whether the means employed to achieve that goal are reasonable. In my view, they are not. The fundamental reason why they are not is because they are overbroad. They are ostensibly aimed at the use of dependent producing drugs that are inherently harmful and trafficking in those drugs. But they are unreasonable in that they also target uses that have not been shown to pose a risk of harm or to be incapable of being subjected to strict regulation and control. The net that they cast is so wide that uses that pose no risk of harm and that can effectively be regulated and subjected to government control, like other dangerous drugs, are hit by the prohibition. So what the court was saying, and what Ngobo J was saying in a judgment where you had Mkhoro and Sachs J concurring, as well as Madlang, who was acting justice at the time, concurring, is that there were less restrictive means of achieving the purpose. There were ways to make sure that people within the Rastafarian community could practice their religious rites and rituals around the use of marijuana without necessarily, just being banned from using it. And what the ministry argued, and what they had the different officials coming in to say, no, it's going to be expensive, we need to do all of this, make regulations, and the court said, no, it's not important that you have to do those things. What's important is that this right must be honored and respected. What they then did was they put the task back to the legislators and the officials to say, figure it out. But fundamentally, we think that you have violated this, and actually the violation is not constitutional. So that's what happened in those two particular cases, and they inform a lot about how we should think around the question of the vaccine mandate in and of itself. So the test is as follows. Firstly, is there a violation of the right? Number two, is that violation fair? And how do you test the fairness? Firstly, is it reasonable? Is it justifiable? And are there less restrictive means? And you can then go to try to understand, how does the court think about this? MEC for Education KwaZulu-Natal versus Pillay, Prince versus the President of the Law Society, as well as the case of Christian Education South Africa versus Minister of Health. And even in criminal law, you'll find that there are questions there, because there was a person in one of the cases in Kaba who had a bullet in him.
Minister of Safety and Minister of Safety versus...
Yeah, exactly. He wanted the bullet out. The police wanted the bullet out. But fundamentally, when the issue was resolved, it was deemed that it would be a constitutional violation to get that
forcibly get that
exactly
out of...
So these are the questions, and these are the thoughts that must be considered. And to be honest, I've not seen this level of analysis on any of the platforms of discourse. And I think that is a disservice to everyone who cares about this topic.
Jamie, I want to come to this issue now. What about company autonomy?
That's an interesting question. And that question...
Because there's this thing that companies are different, different beast altogether.
Yeah. So what the Constitutional Court said in Pillay is that the court will not abdicate its duty by letting companies be the ones who determine these things exclusively. So companies won't be able to say, no, it's our mandate, it's our prerogative. No. And in fact, the court further went on to say this, and this is powerful to note. They said the reality is that many individual communities still retain historically unequal power relations or historically skewed population groups, which make it more likely that local decisions will infringe on the rights of disfavored groups. And the unvaccinated can be considered, in some extent, a disfavored group, because obviously, they're not wanting to vaccinate. People are like, but we need to get on with life. We want to go back to things. The court says, no, we have to consider the company may be more powerful than the individuals whose rights are being infringed. And we are not going to leave our work as the court because you asked us to defer to you and your wisdom as the company.
But Jamie, one could argue this point, right? To say, but what about the cost to the business and the state for this reasonable accommodation?
That's a good question. And the court has actually spoken about this, right? They've said that in Prince, that these things can cost money, but we need to protect these rights, right? Remember, this comes from the concept of dignity. It comes from the concept of freedom. And the court is not going to put a cost judgment on how much does it cost to make reasonable accommodations, right? The court is saying those reasonable accommodations may cost you something, right? But we are not necessarily going to say just because it's expensive, we're not going to do it. That's what the answer is to that particular question.
Okay, Jamie. An important question also, just on that thought. What about the abuses of exemptions? I mean, how do we look into that?
In paragraph 107 of the Pillay case, the court dealt with this. They said, look, there may be a possibility that other kids may want to put nose studs in their noses, not for religious or cultural reasons, but the possibility of abuse should not affect the rights of those who hold sincere beliefs, right? And even in the Prince case, this issue was traversed, that you need to make robust systems with the right level of scrutiny to make sure that abuse is mitigated, right? But you cannot say that because there is scope for abuse, therefore we are not going to do the thing, which is the honoring of somebody's rights. So if indeed the rights exist and they are deemed to be valuable, linked, because remember that this idea of consent is linked to freedom, is linked to dignity, and religion is also linked to dignity, as is culture, right? So these are important rights. We must never forget that this is a democracy which is built on the principles of dignity, equality, and freedom. So it may very well be the case that, the courts may say, listen, it's expensive to make reasonable accommodations. It's expensive to try to accommodate less restrictive means of achieving the public interest of reducing the spread of COVID-19. But we can't actually say that just because there's potential for abuse or it's expensive, we're going to prevent people from enjoying rights that the Constitution already says are the bedrock of the democracy.
Jamie, thank you for that constitutional analysis, but what about the fairness to those that have taken the vaccination? I mean, how should they feel about this?
Well, in Pillay, the court also dealt with this issue of unfairness, because people say, listen, it's unfair. Other people are following the rules. They'll feel like the school, now someone has got special treatment, while Runa, we don't have special treatment. What the court said in para 103 around unfairness to others, they said that, listen, it's unfortunate that you may feel unfairness, right? But neither and here they're talking about the Equality Act, remember, but they say neither the Equality Act nor the Constitution require identical treatment. They only require equal concern and equal respect, right? That's what they said. And then in Christian education, the court stated, to grant respect to sincerely held religious views of a community and to make exception from a general law to accommodate them would not be unfair to anyone else who did not hold those views. So even if you are vaccinated, even if you're pro-vaccine, I'm pro-vaccine, I'm vaccinated.
We're all vaccinated.
But that doesn't necessarily mean that the court will agree with us that just because we're vaccinated and we're pro-vaccine, therefore, in the spirit of fairness, other people must also vaccinate. If they genuinely hold various views and reservations around maybe the idea of Section 12, which deals with bodily integrity, and as we've seen in the National Health Act, which gives more detail to what does consent actually look like, religion, and also people want to be able to access institutions of higher learning. How do you go to a library or a computer lab if you cannot access the university and you don't have a computer or those library books? How do you, for certain occupations, actually exercise your right to enjoy your occupation of choice. So, as much as we may feel that it's unfair, the Constitutional Court has said that our feelings are not material to their consideration on this issue.
Ladies and gentlemen, that's all that time that we have. Jamie, thank you so much for clearing and really providing this constitutional law analysis. To you, the viewers, let us know what discussions and debates arise from this. We do understand, the topic and how important of a conversation is. So engage with us. That's all the time that we have. My name is Baton Khotokwane, Senior Analyst, Jamie Mighty.
Thank you so much. And just to conclude, this is a very, very meaty topic, and it's one that is very relevant to our discussion. And our agenda today is just to help everyone think through this thing. Whatever you conclude at the end, that's your personal convictions. Whatever happens at the end, that's your personal convictions. And we are more than happy to continue having this debate with you on all of the platforms. If you're watching on YouTube, comment, like, subscribe. If you're watching on the other platforms, social media, follow, share, retweet, comment, whatever it may be. I think this episode has been one of my favorite because it's such an important topic, and everyone else has been playing games.
Definitely.